Welcome to This Explainer. Today we're diving into the invisible legal framework that quite literally powers our global economy. We're talking about intellectual property, or IP. We're going to unpack exactly how the creations of the human mind get safeguarded, which is absolutely crucial for creators and businesses to actually thrive. All right, so here's our roadmap for how an abstract thought transforms into a legally protected money-making asset. We'll hit the power of ideas, the 4 pillars of protection, figure out who actually owns your ideas, zoom out to the global IP economy, and finally, look at protecting IP today. Let's jump right into Section 1, the power of ideas, going from intangible thoughts to concrete assets. Think about the vast difference between something you can lock in a physical vault, like a car or a plot of land, and a valuable idea that can be copied in literally an instant. Intangible assets, like a brilliant new app, a catchy song, or a brand logo, hold immense commercial value. But, by their very nature, they're incredibly easy for someone else to just replicate. You can physically fence off a piece of land to keep trespassers out, right? But how on earth do you fence off a brilliant idea once you've released it into the wild? Well, the crucial point here is that without legal protection, anyone could just steal your hard work, and that completely drains the financial incentive to invent anything new. Economists actually call this the free rider problem. Imagine you spend years and thousands of dollars developing a revolutionary product in your garage. You finally launch the thing, only for a massive competitor to immediately copy your design and sell it for half the price, all without paying a single dime for the R&D. I mean, if that happened, why would you ever innovate again? Intellectual property laws exist to stop that exact nightmare scenario. Now, this isn't just some modern internet age concept. Humanity has actually relied on laws to protect ideas for centuries, to ensure societal progress. Going way back to 1623, the Statute of Monopolies laid the very first groundwork for patents. Then in 1710, we get the Statute of Anne establishing early copyright law. And by 1867, the North German Confederation's constitution was officially throwing around the term intellectual property. So society has known for a long time that rewarding creators is the absolute key to technological and cultural advancement. Moving on to Section 2, the 4 pillars of protection. Basically, the creator's toolkit. So we've got these 4 core pillars of protection, and each one covers different creations for vastly different lengths of time. We've got patents for inventions, copyrights for creative works, trademarks for branding, and trade secrets for confidential info. And just look at those durations. You've got a strict 20-year ticking clock for a patent, compared to something that can potentially last forever with a trademark or a trade secret. Let's break these down one by one. First up, the patent. This protects inventions that are new, useful, and non-obvious. Now, I'll be honest, patents are notoriously expensive and incredibly complex to obtain. Definitely don't try to navigate that system without a specialized attorney. But in exchange for all that headache, they grant you a massively powerful 20-year monopoly on your invention. For 2 whole decades, you hold the absolute exclusive right to stop anyone else from making, using, or selling your creation. To put that incredible power into perspective, just look at the pharmaceutical industry. Innovators who are creating biotech disease detection methods or new life-saving drugs, they spend billions of dollars on research and development, often over the course of an entire decade. Without patent protection, pharma companies simply wouldn't take those massive financial risks. They desperately need that 20-year window of exclusivity to recoup their costs and actually turn a profit before generic competitors are legally allowed to swoop in. Okay, our second pillar is copyright. Whether we're talking about a best-selling book, an MP3, software code, or a photograph, copyright automatically protects your creative expression the exact moment it's tangibly recorded. That's the real beauty of it. You don't necessarily have to wait on this protection. It's automatic. And it typically lasts for the entire life of the creator, plus an additional 70 years. It gives you the exclusive right to decide exactly who gets to reproduce, display, or adapt your work. So how does this actually play out? Imagine a huge corporate brand pulls a photographer's beautiful image right off the internet and blasts it across a massive billboard ad campaign without even asking. Well, thanks to automatic copyright protection, that photographer has the full weight of the law behind them. They don't have to just sit there and watch their work get exploited. They can step in, demand hefty financial compensation, or legally force the company to pull those ads down immediately. Moving right along to the third pillar, the trademark. Now, trademarks are absolutely essential for businesses because they legally protect your hard-earned reputation. At the end of the day, they exist to prevent consumer confusion. When a buyer sees your specific logo or brand name, they need to know for sure they're getting your authentic, high-quality product, not some cheap knockoff trying to trick them into a purchase. It's crazy to think about, but simple shapes and symbols can hold immense, literally world-changing commercial value. Think about the distinctive Nike swoosh or the golden arches of McDonald's. Those aren't just doodles, right? They're globally recognized assets representing billions of dollars in consumer trust and loyalty. Trademark law provides the legal teeth to ensure competitors can't just ride the coattails of that brand recognition by making similar, confusing logos. And that brings us to our final pillar, the trade secret. This is confidential information. We're talking proprietary formulas, exclusive customer lists, internal business strategies, stuff that gives you a real competitive advantage. Now, unlike the other three pillars, this one requires zero government registration. No paperwork to file here. You just lock the doors, encrypt the hard drives, and aggressively enforce strict non-disclosure agreements with anyone who gets access. The cool thing is, if you can successfully keep a secret locked down, its legal protection can quite literally last forever. The Coca-Cola formula is the legendary example here. Think about it. If the company had chosen to patent that recipe, it would have become public knowledge, and the patent would have expired decades ago. But by fiercely guarding it as a trade secret, they've kept an exclusive competitive edge for well over a century. Okay, let's hit section 3, who owns your ideas? Understanding the concept of work for hire. This is truly the million-dollar question for employees, freelancers, and business owners everywhere. Let's say you come up with an incredible, totally patentable invention while sitting at your desk at work. Who actually gets to claim that intellectual property? Well, the reality is that your employment contract usually dictates ownership. If you create something completely independently, on your own time, with your own resources, it's generally yours. But under the legal doctrine of work for hire, inventions or creative works produced during the scope of your employment, those belong to your employer. This is exactly why carefully reading those NDAs and employment contracts is absolutely vital before you start innovating on the company's dime. Moving out to the big picture with Section 4, the global IP economic, fostering worldwide innovation. Because modern businesses operate globally, international agreements are absolutely essential to ensure your ideas aren't instantly stolen the second they cross a border. There are two major international forces keeping this whole global IP economy running. First, WIPO, a UN agency, focuses on harmonizing laws worldwide and resolving disputes. And then you have the TRIPS agreement. That sets the absolute baseline minimum standards for IP protection that member nations have to strictly enforce if they want to play in the global trade ecosystem. Ultimately, robust IP protection is the baseline engine driving technological advancement worldwide. Countries with strong intellectual property laws just attract way more foreign investment. And this is especially true in the tech sector, where developing new software or hardware requires massive upfront capital. I mean, companies simply aren't going to expand into countries where their innovations will be immediately pirated by local competitors with absolutely zero legal recourse. Which brings us to our final section, Section 5, protecting IP today and the specific challenges of the digital age. Look, protecting your livelihood today requires taking proactive legal steps and staying hyper-vigilant against digital piracy. You really can't just cross your fingers and hope for the best anymore. Step 1 is registration. You've got to get your rights officially on the books. Step 2 means setting up strong internal controls, like NDAs and serious cybersecurity, to lock down those unregisterable trade secrets. And step 3, that's action. You have to monitor the market and be totally ready to enforce your rights, whether that's sending a cease and desist letter or filing a full-blown lawsuit. With global supply chains and the internet making copying easier than literally ever before, understanding and utilizing IP rights isn't just something for massive multinational corporations to worry about. It's a fundamental tool for anyone looking to turn their ingenuity into lasting value. So I want to leave you with this. As the internet accelerates the spread of information at warp speed, how vulnerable are your own intangible ideas right now? Make sure you protect your mind's creations, because at the end of the day, they are your most valuable assets.